When you read a major court opinion or, hear a judge deliver a verdict, the whole thing, the entire ritual is designed to project one thing: absolute, unshakable certainty.
Mm.
The law, we're told, is this deductive machine. You feed in the facts, apply the logic, and bang, the inevitable outcome is revealed. It's presented as objective truth.
Right.
But what if that projected certainty, the bedrock of our modern justice system, what if it's fundamentally, a meticulously crafted psychological illusion?
That is the crucial question, isn't it? And that's really what underlies this deep dive today.
Mm-hmm.
We're opening up the sources that explore the psychology of judging.
Okay.
Our mission, really, is to peer into that vast gulf between the formal, almost mechanical appearance of legal decision-making
Mm-hmm.
and the actual, sometimes chaotic, internal mental processes involved.
Right.
I mean, for decades, legal scholars have basically been asking for this kind of psychological X-ray. They knew they lacked the techniques and tools which are sensitive enough to explore the mind of man and report accurately its conscious and subconscious operations.
And this skepticism, this idea that it's not just a deductive machine, it's not new at all, is it?
Not at all. Decades ago, thinkers were already protesting.
Yeah.
You had scholars like Justice Cardozo who described the judicial process not as like clockwork, but as these introspective searchings of the spirit.
Mm.
The formalized opinion, he kind of suggested, was often written after the fact.
Mhm.
A rationalization for something deeper, maybe.
A rationalization. Okay.
And if you want a perfect image of this instability,
Yep.
you have to look at Jerome Frank.
Yes, Frank.
He was maybe the most vocal protester against this idea of forced judicial certitude.
Mhm.
He argued it was often just a way of concealing profound uncertainty.
Right, hiding the doubt.
Exactly. And he gave us that unforgettable image, didn't he? He said, judicial reasoning resembled the necks of the flamingos in Alice in Wonderland, which failed to remain sufficiently rigid.
To be used effectively as mallets by the croquet players. I love that visual.
It's fantastic.
Such a great metaphor for unstable logic. So, okay, if the law is inherently unstable, if the judge's mind starts with these wobbling flamingo necks of contradictory arguments, our key mission today is to understand the psychological process. How does the mind stabilize that conflict? How does it arrive at one confident, coherent answer? And crucially, what are the deep implications of that cognitive mechanism for the integrity of decision-making?
That's it, precisely.
Okay, so let's unpack this core paradox then. As Carl Llewellyn noted, judicial opinions have to be dressed up in the garb of certainty.
They must.
You don't get to publish an opinion saying, well, I was 51% sure on this one. No, the final product has to be ironclad.
Right.
So if the raw input is contradictory precedents, maybe ambiguous legislative intent, conflicting arguments, how does the judge's mind psychologically enforce that final ultimate conviction?
Well, what's fascinating here is that we really have to abandon the idea of linear, step-by-step deduction. That's just not how the mind seems to work in these complex situations. Psychologically, the decision process involves more of a restructuring of the legal materials. Think of it less like a spreadsheet and maybe more like a massive interconnected network in the judge's mind.
A network.
Yeah, where the arguments and facts start sort of fighting each other.
Yeah.
The mind is constantly driving toward balance and coherence.
When you say fighting each other, are you talking about the judge actively, consciously debating the points? Or is this something happening more subconsciously?
It seems to be largely subconscious, yeah.
Yeah.
And the core mechanism they talk about is called constraint satisfaction.
Constraint satisfaction.
Imagine all the elements,
Yeah.
the facts, the precedents, the legal principles, as points in this huge web. The connections between them are the constraints.
Right.
So if two facts support each other, that's an excitatory link, a positive connection. If argument A and argument B are fundamentally contradictory, that's an inhibitory link, a negative one. The system doesn't try to solve the conflict using formal logic, not initially anyway. It works over numerous cycles of activation, almost like waves washing over the network. It's essentially trying to find the configuration that maximizes overall satisfaction and minimizes internal contradiction.
So it's like a cognitive pressure cooker, forcing the elements to line up, kind of.
Exactly. That's a good way to put it. Elements that receive massive support from their neighbors, they strengthen, they thrive. Elements that are constantly being suppressed or contradicted by stronger neighbors, well, they degrade and die out, according to the sources.
They just fade away.
They fade away. And this system, it very efficiently generates a mental model that is highly coherent and supports one side. That's the ultimate decision.
Now, here's the part that, for me, truly changes how you view legal decisions. If the judge reaches this confident decision through constraint satisfaction, what happens to the opposing arguments, the ones that died out?
Yeah. This is the critical and honestly pretty staggering realization. Because the system generates coherence by strengthening one model and actively suppressing the other.
Right.
The resulting judicial opinion only depicts the winning decision. It conveys this extremely high level of closure, of certainty.
Yeah.
But we know from this model that the suppressed model, the fully developed set of arguments for the losing side, is often not much less coherent.
Wow. So the opinion you read is presented as totally inevitable, like the only possible outcome.
Yeah.
But in the judge's own mind, there was a near-perfect counter-argument that was simply suppressed to achieve that feeling of cognitive closure.
That's what the model suggests.
That fundamentally undermines the notion that judicial outcomes are purely objective searches for the single correct legal answer, doesn't it?
It certainly challenges that simple view. It shows the human brain's inherent need to enforce clarity, to find coherence even where it might not naturally exist. And we can see how much heavy lifting the judge's mind has to do in really complex cases. Look at the Ratzlaff opinion, for example, which dealt with complex legislative intent.
Okay.
The analysis in the source shows the legal arguments were just fraught with complexity and contradiction. The justices generated 23 arguments, resulting in 8 inference paths. And 3 pairs of those paths were directly contradictory.
So a real tangle.
Real tangle. The source material notes that neither conclusion, whether specialized knowledge was required or regular knowledge was sufficient. Neither conclusion was supported by a naturally coherent subset of arguments. The judge's mind didn't find coherence. It had to, well, impose it.
That shifts the whole dynamic, doesn't it? From finding the law to actively structuring the law.
In a way, yes.
But let's move past this internal structural conflict for a moment and look at something perhaps more familiar: pure cognitive shortcuts, biases.
Ah, yes.
Because here's where it gets really interesting for me. Studies consistently show judges are susceptible to the exact same biases and psychological tricks as, well, everyone else.
The evidence is pervasive, yeah. It's quite compelling. Consider the powerful anchoring effect.
Right, anchoring, where an initial number influences you, even if it's irrelevant.
Precisely. In one trial simulation study, judges were given a case and exposed to a highly specific but, and this is key, meritless motion to dismiss.
Okay, meritless, so it should be ignored.
Correct. The motion was based on a low jurisdictional minimum, $75,000. Now, even after correctly denying the motion, the judges who had simply been exposed to that arbitrary $75,000 number, they awarded the plaintiffs significantly less in damages.
So much less.
Nearly 30% less on average. The median award was around $882,000, compared to a cool $1 million for the control group who never saw the motion.
Wow. An irrelevant low number pulled down a nearly $1 million judgment by almost a third. That's powerful.
It's incredibly powerful. And then we have the challenge of hindsight bias.
The I knew it all along effect.
Exactly. It's the tendency to believe, after an event has occurred, that you knew it was going to happen all along, or at least that it was much more predictable than it really was. Judges are meant to assess predictability based on what was known before the event, of course.
But they struggle.
Oh, they struggle just as much as lay people do, it seems.
Yeah.
In one study looking at appellate predictability, judges were told the outcome of an appeal. Then they were asked to estimate the likelihood of that specific outcome occurring, but as if they were judging before the appeal happened.
Okay, so trying to erase the knowledge of the outcome.
Trying to, yes. Unsurprisingly, they significantly overestimated its predictability. But here's the really counterintuitive detail for you.
Go on.
When the percentages of judges predicting the outcome they were given were added up across different groups, the total was 172%.
Wait, 172%? How does that even work?
Yeah.
If they were objective and split their predictions, the sum should be 100%, right?
Exactly. 100% would represent perfect, unbiased aggregate prediction.
So what does 172% tell us?
It tells us they were fundamentally unable to separate the knowledge of the past outcome from their pre-event prediction. It's literally impossible to be 172% predictable.
Right.
It means that judges who were told outcome A was the result retroactively believed A was highly predictable, and judges told outcome B was the result retroactively believed B was highly predictable. The past always feels much more determined, more inevitable than the messy, uncertain moment of decision ever actually was.
Okay, that's quite unsettling. And it raises an important question, doesn't it? Can judges truly remain detached when their gut reaction, their feelings about the people involved, kicks in?
Well, the sources suggest not always. There's evidence of emotional influence.
Like what?
In an experiment involving a challenge to a strip search, researchers found a really dramatic difference based purely on the litigant's described persona.
Okay.
Get this, 84% of judges granted summary judgment to a female plaintiff who's described as a student,
Huh.
but only 50% granted it for a male plaintiff described as a thug.
Wait, even though the facts were the same?
Even though the underlying legal facts and the procedural posture of the case were absolutely identical.
So just the label, student versus thug, potentially swayed almost a third of the judges.
The numbers strongly suggest that decisions can be swayed significantly by the judge's subjective feelings toward the litigants, who they empathize with, perhaps.
And if they struggle with personal feelings, I imagine they certainly struggle with things they are explicitly told to ignore.
That seems to be the case. We see the difficulty of ignoring inadmissible evidence.
Right.
Judges are trained, rigorously trained, to filter out relevant but inadmissible details, like maybe a plaintiff's prior criminal conviction in a civil suit, or a confidential settlement demand figure. Yet studies show these details measurably influence their sentencing decisions or their damage awards.
Even when they tried not to let it.
Even when they consciously try to disregard them, it just sort of leaks in.
It reveals the limits of conscious willpower, maybe.
It certainly suggests that. So, if intuitive thinking, what psychologists often call system one, that fast automatic thinking, if that leads to these systematic immediate errors, what's the firewall? What does the system have to mitigate these errors?
Is there anything?
Well, one potential check, mentioned in the sources, is the discipline of writing the opinion itself.
The act of writing it down.
Exactly. That act of formally constructing a narrative, a coherent, externally defensible explanation that might force the judge out of that quick, intuitive system one thinking and induce more deliberation, more careful system two thinking.
So the requirement for giving written reasons, it acts as a kind of challenge to our own internal cognitive shortcuts. It forces us to slow down and actually verify the internal coherence that constraint satisfaction imposed.
That seems to be the idea. It forces a justification that has to hold up to scrutiny, not just feel right internally.
Okay.
And this highlights why formal rules governing recusal and disqualification are so essential, not just for actual bias, but for maintaining the appearance of impartiality.
Right, because if the bias is subconscious...
Exactly. If a judge can't reliably discern which evidence is polluting their judgment, because some of these biases operate entirely below conscious awareness, then stepping away when the appearance of bias exists is maybe the only viable safeguard for public trust.
Makes sense. Let's broaden our scope a bit now. If we know the human mind is wired with these systematic shortcuts, these ways of thinking, how does that wiring affect how we process legal and social rules more globally? We've been focused on judges, but this applies to everyone, right?
Absolutely. It's fundamental human cognition. We see that humans seem to have evolved cognitive mechanisms that are tailored for specific types of problems, and these often bypass pure formal logic.
Meaning
we aren't wired to be perfect formal logicians across the board. A great example from evolutionary psychology is the idea of social contract algorithms.
social contracts,
What?
like fairness, reciprocity.
Exactly. These seem to be specialized mental modules for problems like detecting cheaters in social exchanges. They follow a simple, powerful evolutionary rule.
Right.
Basically, if one takes the benefit, then one must pay the cost.
So our brains are automatically better at spotting someone breaking a social rule, like sneaking into a concert without paying, than they are at solving an abstract logical puzzle, even if the structure is the same.
That's what a lot of research suggests, yes. It's a pragmatic evolutionary wiring for navigating social life.
Okay.
And this interplay between specialized, automatic, often subconscious processing, system one, and slower, conscious, more logical thought, system two, it brings us to a really contemporary concern: the potential weaponization of these cognitive vulnerabilities.
Right. You're talking about the dark side of influence, what the military sphere now calls cognitive warfare.
Yes, exactly. It's defined in some sources as deliberate offensive maneuvers aimed at influencing beliefs and behavior by directly targeting the human mind. The attacks are often synchronized across multiple channels, and critically, they're designed to manipulate emotional and subconscious processes, the very system one mechanisms we've been discussing. This makes the threat incredibly difficult for the conscious mind, for system two, to even perceive let alone counter.
So the same cognitive vulnerabilities that might allow an irrelevant $75,000 anchor to sway a judge's damages award,
Yeah.
or perhaps make them susceptible to feeling bias for a student versus a thug. Those very vulnerabilities can be systematically exploited on a massive societal scale.
That's the potential link. Yes, that's the concern. And that brings us right back to integrity, but on a larger scale.
How so?
Well, we could think about corruption in society not just as, illegal payments changing hands,
Right.
but as the fundamental violation of the impartiality principle, breaking those non-discrimination norms for personal or group advantage. This kind of widespread corruption, which we know leads to uncertainty and demonstrably hurts things like GDP. You could see it as a societal manifestation of a lack of commitment to objective, non-personalized decision rules. It's the macro-level integrity failure potentially stemming from these micro-level cognitive limitations and biases.
Wow. Okay. So we've really covered some ground today. We've seen the journey of the judicial mind from this idealized deductive machine to one constrained by the inherent human need for cognitive coherence. We've established that the brain naturally seeks competent closure, sometimes by, well, suppressing a nearly equally valid counterargument.
Right.
And it's subtly influenced by cognitive errors like anchoring, hindsight bias, even feelings about the people involved.
And that psychological need for coherence, that drive, it ensures that the legal process always yields a confident decision one way or another.
Yeah.
Now consider this, because judicial opinions serve as the primary teaching tool in law schools. The entire legal curriculum effectively trains future lawyers to impose coherence over conflict and to replace doubt with confidence. That becomes the ingrained methodology, the habit of mind for the profession.
Okay.
So, if that is the ingrained method, here's a final thought to leave you with. What fundamental changes might legal education need to embrace to cultivate the opposite quality? That is, the mental capacity for genuinely contending with openness and conflict, a trait the sources we looked at suggest is absolutely essential for truly grasping the complexity of the human experience.